Hello, everybody. This is John Nahajzer. I'm here with Jim Alexander. We're the two managing partners of Maggio and Kattar. We wanted to welcome everybody who's joining us for this webinar. We see that people are still joining, and so we wanted to give folks another 30 seconds or so to log on. But I think we're going to just start by saying, by just issuing a couple of housekeeping instructions. We're going to reserve questions for the end. We made sure to leave plenty of time for Q&A, and apparently there are going to be instructions issued at the end by the host, who will provide you with those details. We're also recording this webinar, so we'll be able to issue the recording to any of your colleagues that missed the webinar and might be interested in hearing it. So we'll pause another 30 seconds, as I said, and then we'll begin.
Good afternoon, everyone. This is Jim Alexander. I'm the other managing shareholder at Maggio and Kattar. And today's discussion is on U.S. immigration under the Trump administration. President Trump took the oath of office on January 20th, and it's very clear that immigration is at the forefront of this administration in terms of their priorities. We've already seen a number of executive orders signed by President Trump. We want to today make sense of these various executive orders, talk about some of the leaked executive orders that have been provided to the media by the administration, and then also look at proposed legislation. All of this has created a lot of uncertainty and chaos within the immigrant community, within various communities in the United States, and amongst employers. So we're here today to talk about what these executive orders mean and how employers can prepare in anticipation of these changes within U.S. immigration policy.
Yeah, what's clear, what a lot of my clients are asking is when are these changes going to happen? It's almost as though it's a given that the changes will occur. And I think what we can definitely expect is heightened enforcement, and for sure. And by that we mean of the immigration rules themselves. For example, site visits, probably more site visits, increased scrutiny at the ports of entry and at consulates for visa applications. As well as I-9 audits. I think that the president has made it clear that with the addition of hundreds, I think, of ICE officers, that I-9 audits are going to be a focus. We also, as Jim mentioned, we wanted to talk about, and throughout the presentation, we'll try to drop in strategies for companies to try to mitigate some of this risk and to avoid the disruption, because after all, that's what our clients would like to accomplish here. So here we go. Go ahead, Jim.
So the Trump administration, as you all may already know, has signed 3 executive orders addressing immigration. In addition to the 3 executive orders that have been signed, there has been an executive order with regard to employment-based immigration that's been leaked. And then we've seen a number of proposed bills introduced regarding immigration. Now, with regard to the 3 executive orders, this has been the focus in the media because these executive orders, many of the issues that are raised in these executive orders, there's an immediate impact, and probably most clear is the impact on individuals who are trying to travel to the U.S. or to apply for visas or to seek an immigration benefit. One of the executive orders specifically addresses how immigration and U.S. immigration should handle benefit requests from individuals who are from 7 different countries. In addition to the benefit requests, it instructs consulates to not issue visas for individuals from these 7 countries, and it instructs the border patrol officers to not allow individuals in from these 7 countries.
Now, the executive order that concerned employment-based immigration was leaked at the same time. It's still a draft. Okay, so clearly, to be clear, it's not been signed by the president. It's in draft form, and we're going to talk about it in great detail later on in this presentation. It may never be signed, or it may be signed in some different form. We don't know. But it's good to, I think, have this discussion because, again, we're being bombarded by questions from concerned clients. And I think it has to do with the timing of the leak, right? It was
Absolutely.
issued during the first week, right, of his presidency when the travel executive order was signed.
Right, and I think there's a lot of anticipation out there because President Trump made it clear that he was going to be focused on immigration issues. There was a lot of anticipation, and when this order was leaked, there was a lot of speculation and concern about its impact on businesses and foreign national employees.
That's right. And in terms of the legislation that we're going to talk about at the end of the presentation, we're focusing on some of the newest proposals. There's still only bills sitting on Capitol Hill, right? And they've not been signed. And we've seen bills now for the past, decade or so that have previous 2 administrations which have gone nowhere. It remains to be seen whether or not these new bills will actually any of them will be enacted into law.
So with regard to the 3 executive orders, we're going to start with the 2 that were signed on the same day. And both of these orders are still in effect. And what you may want to, the way you may want to look at this is one talks about interior security, and the other addresses security at the border. So the first executive order that President Trump signed was enhancing public safety in the interior of the United States. Here, President Trump basically established the priorities for the Department of Homeland Security with regard to the individuals that they should focus on ensuring their prompt deportation from the United States.
Okay, so just to be clear here now, Jim, these 2 have not been somehow affected by the temporary restraining order. These executive orders are in effect.
That is correct.
Okay.
He also instructed that we would reinstate secure communities, which basically authorizes local law enforcement to perform the duties of immigration officers. As you all may know, immigration is a federal issue, and so it is generally the responsibility of the federal government to execute those laws. Secure communities agreements with local jurisdictions allow local law enforcement to ask questions about individuals' immigration status and to basically serve as immigration officers.
Now, how does this impact our business clients?
Well, one question would be whether they will be asking about the hiring practices of companies. Will they start raising questions about whether companies are properly following the rules for I-9, the completion of I-9s and retaining records? or will they be focused on individuals and their immigration status?
So if I've got a client who's in a sanctuary jurisdiction or a sanctuary city, right, as they're commonly known, then if that city's in a battle, right, with the Trump administration, then there's, I think, an increased risk of I-9 audits, right, because the government is going to take enforcement actions against those jurisdictions. What about arrests? What if in the past, if someone, I would hear maybe, if an employee is going to get a visa stamped, and then I'd hear about an arrest or a conviction or something like that. Usually it's a DUI or maybe a shoplifting charge or something along those lines. Certainly not a crime involving moral turpitude. What should we expect now with this executive order and just an arrest?
Sure. Well, with regard to establishing the new priorities for the Department of Homeland Security, President Trump has identified criminal aliens to include individuals who have been arrested but not convicted. And they are a priority under this administration. Therefore, the Immigration and Customs Enforcement should pursue those individuals and initiate deportation proceedings. And the reason why this is really important for employers is in the last year or so, we've seen consulates around the world start sending emails to foreign nationals indicating that they noticed that after the visa was issued, the individual was arrested. And that may be for a DUI. And that's, I think, the most common situation is where an individual has been arrested for a DUI. But it could be any type of arrest. And the consulate notifies them that they are aware of this arrest and that they are hereby revoking the visa. And usually the letter goes on to say that this does not mean that they are not in the U.S. without authorization or without proper status. It simply means that when they leave the United States, they will need to reapply for their visa and prove their eligibility. Now, this becomes complicated because if these individuals their visas are revoked under Section 221I of the Immigration Act, it automatically triggers a ground of deportability. So what we are starting to see are emails from Immigration Customs Enforcement to individuals indicating that they would like to schedule time to meet with them to discuss their immigration status. That raises a risk. It is possible that these individuals could be detained if they are placed in deportation proceedings. These executive orders give a lot of discretion to the folks around the and within Immigration Customs Enforcement. They're going to have the ability to decide whether someone should be allowed to continue, in H-1B status or L-1 status or whatever status, or whether they should be detained.
So an arrest could mean that your employee will actually be put into proceedings.
That's right.
In deportation proceedings.
That's right.
Versus with the prior administration, you might just see a simple visa revocation.
Right. The Obama administration had different priorities. Their priorities were to focus on gang members, individuals who were believed to pose a threat to national security, other individuals with actual criminal convictions as opposed to merely arrests.
Okay.
So one of the things that companies, employers will want to do is send out a communication. If you have foreign nationals in your workforce, that if your employees are arrested for any reason, they should be notifying the company so that you can look at the situation and make appropriate plans.
Right. Now, of course, that may be easier said than done because employees would have concerns practically of notifying employers of an arrest.
Right.
So it'll be interesting to see how this all plays out. But these are the EOs that are actually in effect and not affected by the temporary restraining order, unlike this one here. Right now at 6 o'clock Eastern, there's going to be a telephonic hearing, right, with the Court of Appeals.
That is correct.
district, and so we're going to find out what is going to happen to the lawsuit that's pending out there, right?
Right.
So we all know, I think we've all heard about the 7 countries who were impacted by this travel EO, and it may be scrapped or it may actually be put back into effect. Now, over the last couple of weeks, or since the issuance of the travel EO, there was subsequent guidance from the government. And so what began as almost an
anyone and everyone,
right, absolute ban, it translated into non-immigrants, basically, or the visa holders being affected. And then if you were a dual national, you were not necessarily impacted. So the guidance kind of seeped out later, and it wasn't as harsh as initially thought. So this is a remains to be seen. We will issue alerts after the, or any kind of updates after the hearing, and we'll see what happens.
Right, and one issue that the court did not address was the implementation of uniform screening standards. So that is something that could proceed even if the court decides that an injunction should be imposed on the travel ban for nationals of the 7 countries.
Okay. So here's this is the detail. These are the details of the travel EO, which we'll go ahead and skip. I think because we need to see what happens today with the hearing. Okay.
You will notice that the second box, it mentions that the Secretary of Homeland Security is ordered to identify the information required from any country to adjudicate any visa, admission, or other immigration benefit in order to confirm identity of applicants and whether they pose a threat. Non-compliant countries to be included in a presidential proclamation prohibiting entry to the U.S. for nationals of these countries. This section of the executive order was not enjoined. The judge did not touch this part of the executive order. So it is possible that we could still have a travel ban. It could be more expansive or it could be more limited depending on the responsiveness that the Department of Homeland Security experiences with regard to their request for information from countries. So there is still a possibility that even if the injunction is enforced, the Department of Homeland Security may still restrict travel from certain countries.
Right. So I think the bottom line is until all of this is kind of sorted out, travel, if you have an employee who's from one of the 7 countries and is impacted, travel is risky.
Yes.
Yeah, I think that goes without saying. So now, turning towards the the draft EO that was leaked, it affects a wide range of visa types, the ones that our clients are typically used to dealing with. And as I said before, it caused the issuance of this draft EO caused a great deal of concern, and we get questions every day about about this. It's unclear, as I said before, whether or not this EO will ever be signed. It's still in draft form, or what it's going to look like, even if it is signed. Nevertheless, we are, the reason we're having this today is so that our clients can be prepared to deal with potential impact over the long term.
And a lot of this particular executive order, a lot of what it was talking about were things that the president doesn't necessarily have to put in an executive order. He could have asked the Secretary of Homeland Security and Secretary of State and the Secretary of Labor to look at these visa categories without issuing an executive order. But it does give us a glimpse into the mindset of this administration and where they think their attention and energy should be focused.
Okay, so enforcement's, I think part of the theme, and you see that here with some of the priorities that were set forth in the draft EO. And what turn the page here. Basically, what they're getting at is to make sure that our laws are being followed, and they want the Department of Homeland Security to identify ways to expand the use of E-Verify. Many of our clients already are E-Verify participants, but I think the government has a clear goal to try to sign up as many of these companies as possible to E-Verify.
Yeah, and that's consistent with prior administration.
Exactly.
We have experienced mission creep with regard to E-Verify.
That's right. So now the draft EO lists out the visa types that they want to address, right? And here you go. As I said, it's the ones that our clients are used to dealing with. In addition, AOS, which stands for Adjustment of Status, that is the final phase of the green card process for most people, and basically for those who are getting their green cards through employment sponsorship. And so now the duration of this proposed action, the draft said to be determined. Mm-hmm. And when will this go into effect? I think what we're going to try to do is predict out for you the time frames, or at least give you a sense of how long it would take to change some of these the rules associated with the visa types. With some, it's going to take a long time. With others, it could be done relatively quickly.
Yes.
Okay. And here we go. So, according to the draft EO, the Secretary of Homeland Security is ordered to, right, commission a review of all of the regulations for immigration, right, and identify which regulations violate the law or do not align with U.S. national interests. Now, the Secretary is supposed to do this within 90 days. Now, it's not within 90 days of the issuance of this draft. Again, to be clear, this is just a draft. But just to give you a sense of the time frames involved in case the EO is signed.
And I think that when we look at how are they going to analyze whether a regulation is within the national interest, I think that this administration is going to focus on the protection of U.S. workers. It seems that the communication is lopsided in terms of their focus on immigration is abusive. It undermines the interests of U.S. workers, as opposed to a discussion about the benefits that that immigration brings to the U.S. economy and to U.S. workers. Mm-hmm. So I think that when we're looking at the analysis, there is going to be a very strong focus on whether these laws somehow undermine U.S. workers.
That's right. The second bullet point, I think, addresses DACA, does it not?
Yes.
Yeah. So,
does
the president want to take away DACA? We don't know.
It depends. It seems like it depends on the day. We have heard that DACA was going to be immediately repealed, and then we've also heard that the administration doesn't want to negatively impact these children who were brought to the U.S., at a young age, and it was really not their decision to come here, and now they've gone through, they've really become members of their community. So,
right. And with DACA, they were able to secure work permits.
That's right.
And many of you employ these folks. Probably you don't even know it because there's no employment sponsorship that takes place. But I know you do. I mean, I've been involved with some of the questions that have seeped up or through to us. Now, the third bullet point harkens back to what I said earlier, and that is side visits. So today, what we see in terms of side visits are, more or less, I think, relatively extensive side visits for H-1B workers. Mm-hmm. And on occasion, we'll see side visits for L1s, although it's been relatively rare, and then the occasional side visit for a J1. These are the random variety. In the past, and since the beginning of time, immigration has conducted side visits when they've suspected fraud. So they were definitely targeted side visits. These are random.
Right, and the site visit for L1s is limited currently to L1 petitions filed and approved by USCIS. Right. They haven't covered L1 visa holders who obtain their L1 visas under a blanket. The executive order is silent on whether that they're planning to expand that, but I think it's safe to assume that eventually they would like to look at those L1s as well.
I think that I've read somewhere that their thinking is to conduct site visits for almost every L1, which is just astounding given the numbers of Ls that are in this country at any given moment.
Yes.
But that's their goal, is to conduct site visits for virtually every. So if you have any kind of immigration employee working in the U.S. on an H-1B or an L1, they would receive a site visit.
And so for employers, it's really important that you're tracking where your employees are, and to make sure that that the L1 petitions, whether they're filed under the blanket or whether they're filed under an individual petition, that they identify all possible work sites. If there is an individual who changes work sites, please contact Immigration Counsel to discuss whether an amendment needs to be filed.
And this is a good point, because we expect to see, if there's legislation passed, this is probably going to be a component to any new rule changes that will go into effect. Site visits are, I think, politically very popular. It shows that the government's actually doing something, enforcing the rules, making sure that employers are complying with those rules. So Jim's advice, I second that. It's just a good practice to put in place now, because you're eventually going to see something like this in the future, and potentially the near future. Now, the fourth bullet point is nothing new here, right? We've seen prior bills in Congress sort of focus on, when revamping our immigration system, focusing on sort of establishing a merit-based system, right? Almost like the Canadian system. And meaning that what they want to attract are the best and the brightest. And so the inference is, well, to the exclusion of your average engineer, right? And so I think that this means a restriction, right, or a narrowing of the benefits.
That's right, and we're seeing that in some of the proposed legislation just today on Politico.com. There's an article about Senator Cotton from Arkansas. He is introducing legislation that in his first line of legislation is going to focus on family-based immigration as well as the diversity visa, but he's already talking about employment-based categories as well. And his goal is to reduce the overall volume of immigration across the board. So a merit-based system could achieve that goal.
That's right. The next bullet point discusses modifying practical training time for students. So here we're talking about our F1 students and optional practical training, or OPT, which is the work authorization period granted after an F1 student graduates. And many of you, probably all of you, have employed an F1 student in OPT and then can try to convert him or her to an H-1B. What this means is basically reducing the amount of OPT time. Currently, with STEM extensions, right, you get up to 3 years of OPT. That was a change that occurred during the Obama administration. So what we're thinking here is that the Trump administration would like to shorten the amount of time that students are allowed to work in OPT.
But with the last box that you see, or bullet point that you see here, produce a list of options to expand employer participation in E-Verify. John, are we going to be at the same place as we are currently, where they say, hey, one of the ways that we could in fact get more employers to participate in E-Verify is to increase the number of years that an F1 student has an OPT?
Exactly.
Because remember that this proposed regulation, I think that also they want to look at the impact of F1 OPT and whether it's a positive or negative impact on U.S. workers. Mm-hmm. So there will be an opportunity whenever regulations are introduced, there's an opportunity for the public to comment on those, and I believe that they're supposed to look at the overall benefit or negative impact that F1 OPT students have on the overall economy.
Okay. Now, by the way, the time frames that are listed there in parentheticals, those refer to the amount of time that the secretary is supposed to complete the designated task. And if there's no time frame listed at the end of the particular bullet point, that means it's immediate. So, for example, the next one, increased monitoring of foreign students. That's supposed to happen right away if this is signed. Now, this harkens back to 9/11, okay, where the pilots of those planes were here in F1 status. They were students, but not monitored very well, obviously. And then the government increased the monitoring, the scrutiny of the F1 program by a tremendous amount, and through the CVIS system. And so what they're proposing now is even more monitoring of the F1s in the United States. Although in my personal opinion is I think we've been doing a fairly good job, right, in tightening that particular area of immigration up. And then the H-2A program, Jim.
Well, H-2As are for agricultural workers, and there's a limited number of those visas. And I mean, it's really beyond the agricultural industry. You don't see H-2As. So for our employers, we don't see a lot of these types of cases.
Right.
But again, they want to make sure that it's an efficient process, because over the last decade, there have been a number of articles where farmers are just deciding not to plant a crop because they can't get their employees into the U.S.
And Jim discussed the last point there about participation in E-Verify. What's interesting here is that there's no discussion of mandatory participation, and that was sort of an idea that's been bandied about for the past several years, but never gained any traction. So we'll see what the new administration says with E-Verify moving forward. Okay. Now, there are more orders, right, in the executive order. At the top of the next slide, the Secretaries of State and Homeland Security ordered to, right, ensure that the actions are in line with congressional intent as they determine when immigrant visas are available. What does that mean, Jim?
Well, we limit the number of visas per year per country. And what happens, and what has happened, is that we have a huge backlog for individuals from certain countries.
And we're talking about green cards here, immigrant visas. So we don't issue an unlimited number. It's by fiscal year, by country of birth.
Right.
Okay.
And so, as many of you know, if you have an Indian national who is being sponsored for a green card and the job requires less than a master's degree, they could wait more than a decade before they can even file their green card application if you start the process today. So that's a positive sign that they're wanting to look at that and see if there's ways to improve the efficiency.
And because you're thinking is it can't get any worse?
Well,
because it could.
Yes.
They could decrease the numbers, actually, right? Or interpret the statute in a way that the numbers would actually decrease.
Yes. It would be interesting for them to do that after President Trump just 2 weeks ago made a very clear statement that he is going to be a good friend to India, because these visa backlogs overwhelmingly impact India and Indian nationals.
Right.
And this information is regularly the topic of media articles in the Indian press.
Okay, so then the order here is to propose regulations that will alter the adjustment of status process for increased efficiency. Now, again, adjustment of status is the last phase of the green card process if you're being sponsored by an employer. And it's typically a review of the foreign nationals, the sponsored foreign nationals, personal as well as immigration history to deem or determine whether or not they're admissible or basically good enough to hold green card status in the United States. And we're not really sure what they mean by that. The process has actually become more efficient over the years. So that's kind of it remains to be seen where they're going with this, but that's what that particular bullet point or part of the order means. And then you want to address the third?
So the third is that the Secretary of State and Homeland Security are ordered to propose regulations that will reform the E2 investor program. So E2 visas are for individuals who are either investors in a U.S. enterprise or they're employees of an enterprise that is majority owned by individuals from their country. And it is really unclear what the goal here is. The business side of President Trump could be interested in creating greater opportunities for people to invest in businesses in the United States. So it may be regulations that could help improve that process, or it could be a review of the regulations and the current system to crack down on certain types of E2 visas where the individual sets up a company in the United States, is the only employee, and is providing consulting services. That may not, meet the legislative intent according to the Trump administration.
Mm-hmm. Okay, and then they also want to reform the J-1 visa summer work program. Now, they're only identifying one very small part of the J-1 visa program. There are many different types of J-1s, from physicians to researchers, students, scholars, and what our clients typically host are the trainees and interns. Those are the two J-1 categories that are most commonly used by employers, and I think this targets those categories. And what the government is concerned with here is the abuse of the J-1 program. It has happened. However, over the last decade, we have seen an enormous sort of enforcement effort by the State Department to shore up the J-1 program. You still see stories in the newspaper. I think Hershey was the latest one from a couple of summers ago, right, where they found abuse. And so what the government's looking at doing here is making sure that the J-1 program isn't being abused. But again, as with many of these orders, the government has already begun the effort. They've been working on this for the past decade or so, going back all the way to the Bush administration.
And it's important to keep in mind that with this executive order, just because he didn't mention the J-1 intern and training, the training visas, it doesn't mean that they may not look at that. This executive order really was not necessary for all of these activities of having the various agencies look at their programs.
Mm-hmm. That's right. Okay, and then the final bullet point is very interesting and a little ominous. I could probably walk down the street and come up with, something here to provide or to present to the president. And I think what this is meant to do is to provide the administration with ammunition on significantly altering the H-1B, L-1, and even the B-1 business visitor category. And each of these visa categories have their own sort of issues or problems associated with them. But what we're seeing here, the theme here goes back to the protection of U.S. workers, which Jim mentioned earlier. And what we think we think they're targeting the companies who don't employ, or the government thinks is not employing these H-1Bs and L-1s directly, okay, and potentially abusing the B-1 program, okay. And here we're talking about largely the foreign-owned consulting companies, typically in IT, and we're definitely seeing a common theme emerge here, which is to restrict the usage or access to these programs, these visa programs and benefits, restricting those access to the consulting companies. Right?
That's right. Yes, and the B1 visa category it is not clear often whether someone can come in on a B1 to perform certain activities or not. I think that John would agree that we spend a lot of time talking with clients about whether the B1 is permissible. So in the executive order, it jumped out at me when they said, well, we're going to provide clear guidance as to when a B1 is appropriate. And that could be good or bad, right?
That's a 180-degree turn from the way the government has approached the B1 program.
It's been like a feel.
Well, the idea has been that we want to promote international business,
yes.
and thousands of people and foreign nationals enter the U.S. every day on B1 business visitor status. Now, it's not a work authorized category with limited exceptions, but what it's meant to do is to promote
international commerce.
Exactly. And so it's a little disturbing, frankly, to see the B1 added to this list. Yes, abuse has occurred with the B1. It's going to occur if you want that kind of liberal movement, in and out of our borders. So that's something that we're going to have to watch very carefully.
And there are mechanisms in place already to check on abuse and to punish those individuals who do abuse the system.
Exactly. So that takes us to the end of the draft business EO. It has not been signed, but this gives you an idea of what the administration would like to change, or what they're looking at changing at least. We definitely think that it's worth taking a look at your immigration programs, long-term strategies and so forth, and thinking long and hard about how those are going to square with what the administration would like to do. Now, this is not going to happen immediately. Even if the president signs this order today, as you can see, the time frames associated with some of these changes are rather lengthy. Okay, so how long, Jim, do you think? I mean, for an H-1B, for the H-1B regs to be changed, right? He can't just change the H-1B regulations overnight.
I think we're looking at least close to a year.
Right.
I mean, during the last days of the Obama administration, there were regulations introduced that were employer friendly. To make immigration less cumbersome and to help individuals who had been in the U.S. for a long period of time. Those were done extremely fast in government time because they were proposed, I believe, at the beginning of the year, and they were finalized 60 days before, about 62 days before President Trump took office. So they were finalized sometime in November. So that just to give you context, the PERM regulations that govern the green card, the first step in the green card process for most individuals, were proposed and were pending for over a decade, right? And so that's not unusual for proposed regulations. So most likely we're going to see a year or more.
That's right. I agree.
But we do see a lot of common themes between what their focus is and then the legislation that is coming out, both from Democrats and Republicans.
Right. Now, so this particular bill was proposed by
Zoe Lofgren, a Democrat from California, actually the Silicon Valley area.
Yep. And so we wanted to walk you through this. This gives you kind of the Democrat side or perspective of what sort of changes they would like to see with with immigration. Now, this is focused largely on the H-1B program, and what we mean by what they mean by the first bullet point is basically taking away the lowest prevailing wage level.
Right. Whenever you have an employee that you're sponsoring for H-1B status, we have to confirm that the employer is going to pay the prevailing wage. And the Department of Labor has its database with regard to prevailing wages for all occupations. And the Department of Labor database shows that there are 4 different wage levels, and the appropriate wage level is determined by the number, the amount of education and the number of years of experience that the position requires. So Representative Lofgren's legislation would eliminate the first level and then puts pressure to basically increase the wages in the other 3 levels that are remaining.
Mm-hmm. And the legislation here would replace the H-1B lottery system with a system that would award the H-1Bs, or the numbers would go to the folks who are highest paid.
Right.
So there's no more lottery under this bill, and instead the numbers would be given to the folks who would have the highest salaries.
That's right. So if in the legislation it gave an example, or this may have been in her talking points, that if you are paying 200% of the prevailing wage at the highest wage level, then you're going to be given priority in terms of the likelihood of receiving one of the H-1B visas that become available each fiscal year.
Mm-hmm. That's right. And then this legislation would do away with the green card allocation system that Jim was discussing in terms of India, and instead we would have a first come, first served system. So we'd still have backlogs.
But it would be across the board. Everyone would have to wait.
Everyone would have to wait. And then for H-1B dependent employers, and a dependent employer is a company that employs, whose workforce is comprised of more than 15% of H-1B workers. And here there are exemptions. There are some. You have to conduct a labor market test if you're an H-1B dependent employer in order to secure an H-1B, unless you pay the H-1B worker at least $60,000 a year, or they have a master's degree in a field that's related to the job. And this would do away with the master's degree exemption and would increase the $60K exemption to $130,000. Okay, so again, that's only for H-1B dependent employers, right? And then we would allocate 20% of, that's how many H numbers are roughly are provided per fiscal year to U.S. employers, okay, across the country. Only 85,000. It's not a lot. That's why we have the lottery system. But under this proposed legislation, we would have 20% allocated to startup companies that employ less than 50 employees. Again, it's to allow those smaller employers who don't have a chance in the lottery to have a chance. Okay, and then finally, the last point is something very discreet, but many of you know exactly what we're talking about here, and you would be allowed to use work experience gained with the sponsoring employer to qualify under permanent labor certification.
And this legislation also would eliminate the ability to have a liquidated damage provision, where if an H-1B employee leaves employment before the end of the 3 years, a company could claw back the legal fees that they spent obtaining that H-1B. This would eliminate that provision of the regulation.
So there are some good things here, but as you can see, there's this sort of, the recurring themes are protecting U.S. workers. You're going to see higher wages for H's and higher costs as a result. Now, this next bill, again, you see is very similar. You would increase the H-1B dependent exemption to 100K, and with no master's exemption. And then basically the dependent employers, that's 15%, right, or more, would be required to advertise for available positions and prove there are no U.S. workers available for the positions if the salary is under 100K.
That's right. And this was introduced by Darrell Issa, who's a Republican, and just trying to read the political situation. Representative Lofgren, she is in the minority. Whether she can get enough votes from Republicans to have her legislation pass both houses is questionable. It may be more likely that Darrell Issa or another Republican piece of legislation could be passed.
And finally, the other one worth noting is the H-1B Enrollment Reform Act of 2017. Again, replacing the lottery, right, and awarding the H-1B numbers to folks who are paid at the higher salaries and non-dependent employers. And you'd see more enforcement, more audits, right, and prevailing wage would be added to the L-1B program. Currently, there is no prevailing wage in order to secure approval of an L-1B, specialized knowledge intracompany transferee. This would add such prevailing wage level.
And we've seen that trend in other countries. Canada now has a wage requirement where, in fact, not only do you have to get the prevailing wage, but it has to be above the normal wage that an individual would be paid for this type of position.
Okay. So and that brings us to the end of our presentation. Excuse me. What we wanted to emphasize again is that there are no immediate significant changes on the horizon. That could change relatively quickly, although even with proposed changes, by the time the process works its way through the system, you're talking about, in many cases, a year or two before any kind of significant change might occur. That said, we definitely are advising our clients to expect changes. We haven't seen changes to these rules, and sometimes when I give presentations, I'll oftentimes say that these rules were created in the industrial age, and it's true. And I sound like a history professor. It sounds funny to me when I say that, but it's true. We're so used to these rules, and they've been modified slightly over time, but we've been used to the same rules and have had a relatively level sort of predictability, if you want to call it a sort of a perspective review over the years, whereas now I think we're entering into this kind of phase where things might be a little bit more unpredictable. So we should definitely expect changes.
Right, and so employers, just to reiterate, one thing that you want to do is make sure that you're communicating to your workforce population and reminding them that if there are changes to their immigration status, their personal situation, including arrests, that they should be in contact with you to look at whatever the changes are. Given the fact that now these individuals are priorities, historically we would have said if someone has a DUI and we were notified that their visa was revoked, we'd say, that's okay, no need to travel right now, but the next time you travel, you will need to apply for a visa, and you may have to go to a panel physician. But if we do continue to see this trend where individuals are notified by Immigration Customs Enforcement and possibly placed in removal proceedings, there may be other things that we would want to consider and taking a more proactive approach. And it really depends on a number of factors. One may be communicating with the Department of State with regard to the revocation, whether it is proper, or two, sending the individual out to reapply now for a visa, and then that would resolve the issue as well, because they would be traveling on a visa that has not been revoked. So there's that issue. Also, look at your workforce population and also consider the contingent workers that you may have. A lot of the legislation and the focus on the executive orders tends to be a negative reaction to certain business models. And you may want to look at those individuals in your contingent workforce who have become critical, because you may want to develop plans for them if they are not able to renew their employment with their current employer.
And you're referring to the consultants. And
That's right.
Right.
Mm-hmm.
Okay. And the last couple pieces of advice, make sure your I-9s are in order. If there's anything immediate out there, it's going to be I-9 audits. We also wanted to basically just remind everyone that we are watching the situation very closely. We're going to continue to issue FAQs and articles and guidance, and probably have more webinars like this over the next several months.
But we're certainly able to assist on I-9 audits. In addition, PAF audits. You want to make sure that that individual salaries are consistent with the salaries that have been stated on the H-1B petitions, and just make sure that everything is accurate there.
Okay. And with that, Brandy, we're going to open this up to questions.
Hi, you have addressed everything related to visas, and I assume it's because the executive's orders have been relating that information. Is there anything that we should be aware as far as individuals, employees that are currently hold a green card from different countries, and you can address those in whatever particular countries you want to talk about, and they are currently applying for citizenship?
Mm-hmm. Great question.
Well, the guidance from U.S. Citizenship and Immigration Services has been that those naturalization applications will proceed. Now, if you have a green card holder from a country that is on this list, anticipate that their applications may take longer to be adjudicated, because they could be doing more extensive background checks than that which have been conducted in the past.
Part of every naturalization application involves a thorough background check and screening, and we would expect that, as Jim mentioned, that those would increase, right? But in terms of green card holders and any of these changes that we talked about, right? These refer to the non-immigrant categories. The executive order dealt with green card holders, and then that was dialed back. And so hopefully there won't be any significant changes to immigration benefits for permanent residents.
So are you
other than length? Yeah.
Are you even including there the countries, the 7 countries that were listed in the ban?
Yes.
Yes.
Okay. Thank you.
Sure.
How are you? Thanks for this nice webinar. I'm currently doing my waiver on H-1B in medically underserved area, and I'm on H-1B status, but I do not have a valid visa because I've been here for 4 years. I was able to procure a parole document and employment authorization document form 512 based on national interest waiver, and I was planning to go back home to Lebanon to have my H-1B visa stamped in 2 weeks from now, and then that was before everything started, and now I'm thinking about pushing this for a couple months for things to clarify, but I'm not sure what's your take on that, if I should wait or I should go now, and if I go there and then don't get my visa on time, can I come back and use my 512 parole document to come back in?
Yeah. These are great questions. They really are very substantive. And this webinar is more for a broad overview. We would encourage you to schedule a consultation with an attorney to go through your entire immigration history so that you can get advice specific to your situation. There is guidance out there, but this would take a good 45 minutes to an hour to kind of go through all these various issues.
Can you, and how can I do that?
If you can send me an email atjalexander,
Alexander,
at
Xander.
Yes, at Maggio, Maggio hyphen Kattar, KATTAR.com. It's at the website is right at the bottom of the PowerPoint. If you email me, I'll make sure that we have someone a consultation scheduled for you very, very quickly.
Okay, I appreciate that. Thank you. I'll work on that immediately.
Good.
Thank you.
Hi, I'm wondering if you guys are hearing any discussion regarding changes to cap-exempt H-1B employers. And that's question number one. Question number two is, does your website or do you guys have anything you can send out? I'm looking for some resources for like site audit planning, just sort of best practices for the public inspection file, that sort of thing. Thanks.
Great question. Go ahead.
With regard to cap exemption, I think that is obviously going to be one of those areas that they will be looking at to see if it's being abused. And I would anticipate some perhaps revisions. Obviously, just before the end of the Obama administration, they issued new regulations that clarified who can take advantage of the cap exemption, and they broadened it. They made it much larger. If the Trump administration is going to dial that back, it will have to be through a rule change, which would require notice and comment. So there would be a substantial amount of time before any type of change would occur. But certainly with their discussion about abuse, I think that they are assuming that there's possible abuse everywhere, and that they're going to be looking at all areas of immigration law. So.
Yeah, and in terms of your question about documents that we have, to assist with, I think compliance efforts, right, with public access files or I-9s, we do. And so you should send an email to either myself or to Jim, and we can get you pointed in the right direction. My name's a little bit more difficult than Jim, but
the spelling at the bottom.
It's at the bottom. Yeah, it's J. And then my last name, which is Nahajzer here, I don't know if you can see the cursor, at Maggio-Kattar.com.
Hey, hello.
Hello.
I would like to know what was the current situation taking when there is an extension of the visas, H-1B extension filings.
Mm-hmm. For someone who was born in one of the 7 countries, or
not in 7 countries, all other countries except the 7 countries.
There's no change. It's slow.
Yeah, it's very, very slow. Unless you premium process.
Right, unless you pay the government an additional $1,225.
Oh, okay. If you pay PM process, there is not much difference.
No, sir.
No.
Oh.
At this time, no.
No changes.
Okay. If there is a new orders come in, if maybe in a week or so, that will affect on even the premium process or current process also?
I don't think so. Again, the procedures for the H-1B, I mean, all of that has to be changed through regulation, and that's going to take a long time.
And rest assured, if there are any new changes, we'll be scheduling another webinar to walk you all through those changes and how they would impact businesses.
That's right.
Okay, thank you.
Sure. You're welcome.
Hi, I have a comment and a question. First, I want to thank you for your generosity in hosting this webinar. And my comment is, I've noticed recently an employer they had a client who they're going to have a site visit, and it's because their employee did not submit an AR-11 address change within 10 days, and I have never heard of that before. So I wanted to kind of draw that to people's attention as another thing to make sure that people are doing, because if you look at the potential penalties for that, they're pretty dire.
Yes, it is a ground of deportability if you don't submit your AR-11 within the 10 days.
And then another just question, I guess, is that out of the proposed laws, the worst one from the perspective of an employer seems to be the one proposed by a Democrat. And I'm wondering, does that reflect the position of other Democrats? And if so, how can we get that legislation off the table?
Well, to get it off the table, I think you're going to have to, I think all of us have to, if you're opposed to something, reach out, or even if you're in favor of something, reach out to your congressperson and make sure that they hear your feedback.
That's right.
And in terms of the political parties, what I've seen in my career, it's 25 years now, and with this craziness, is that the moderates seem to take the more pro-business approach, whereas the folks on the far left and on the far right typically have an anti-immigration sort of posture, and all stemming from different reasons, right? And so it doesn't surprise me to see a bill proposed by a Democrat carry with it some sticks and potential harms to employers and so forth. But I think that these bills, my own personal take on this, I don't know, I'll let Jim comment, is that they're probably not going to go very far. I think that people are so divided on Capitol Hill when it comes to immigration that I think it's going to be really difficult to find consensus. It'll be really interesting to see what happens.
I agree with you.
Okay. Yeah. But thank you for the comment on AR-11s. AR-11 is a form that has to be filed
within 10 business days.
By
the foreign national whenever there is a move.
Non-immigrant.
And lawful permanent resident.
That's right. So they're starting to enforce that rule. They dusted off that old rule, and that's really kind of disturbing, right?
And so with regard to your communication to your workforce population, a gentle reminder on that would be helpful as well.
We always do.
Yeah.
We always, in writing, tell clients that they need to file that AR-11. It's done online. It's very simple to do, and it must be submitted within 10 days of someone's move or change of address.
Hi, thanks for the presentation. Is there any change regarding the H-4 EAD?
Well, no, not yet. Although I think that that's probably one of the benefits that the administration can take away pretty quickly.
It will have to be through a rule change, but it wouldn't be surprising if that was one of the things that they wanted to look at. For those of you who aren't aware, the H-4 spouse of an H-1B worker can apply for a work permit if the H-1B worker has gotten to a certain stage in the green card process, and a immigrant visa is not yet available. This is a relatively new provision, and so if there is a perception that this is somehow undermining the national interest in protecting U.S. workers, then it could be eliminated.
Oh, okay.
And so for employers, it's really important to identify those people that you have on H-4s, H-4 work permits, and you may want to consider eventually, if they've already held H-1B status, filing a new H-1B petition or including them in the H-1B lottery.
Okay. Okay. Thank you.
You're welcome.
Yeah, hi. My name is Marina. My question is, actually, I have several. I am in the horse business, so in producing sport horses, selling horses, building a school. Question is, there are a lot of southern people working in this horse industry. That is, those are Mexicans, San Salvador, Guatemala. How can we get people from there into this country? I am talking about a particular individual who had to leave the country because the immigration status ran out several years ago now. I would like to bring this person back. And my question is, has anything changed? How can I go about it?
Well, Marina, it sounds like a consultation would be really helpful because there could be several different options that you would want to look at. In terms of short-term temporary work visas, it may be possible for an H-2B. But then it sounds like this is someone who's really valuable, and you may be looking at the question of how do you keep this person permanently, and there you may want to look at permanent residence and sponsorship through the PERM process. And we're happy to talk with you about those options and any other options, and that would be appropriate during a consultation. And if you email me or John, we're happy to set that up for you.
Okay, yeah, I already have worked with your firm ever since Michael Maggio started it many, many years ago. So
Yes.
I'm familiar with that, so I will contact you. Okay, number one. Number two, I also am looking for and that's a very specific area, and that is rock blasting. So an explosive engineer. I would like to bring somebody in from Europe, and how am I going to go about that?
Great question, and we could certainly talk about that during the consultation. We would want to get a fuller picture. This sounds very interesting. There may be the PERM sponsorship. There could be other avenues. When you have a skilled worker, meaning someone who is working in a position that normally requires a degree, there's usually more options than, say, someone who is working in a position that doesn't necessarily require a lot of training or education. So we're happy to look at both of those situations with you.
Okay, very good. Well, and then I have a third one. That's a doctor who is working in the research, medical research. He would like to be more flexible in choosing the university or the hospitals where he works, but he is very tight to where he is right now because the visa is just employer specific. That's it. So he would like to change that the status so he is legal, but he would like to work for another institution.
Well, we have a number of attorneys who focus on those special issues that doctors face with regard to immigration, and we're happy to talk with that individual. There are certain circumstances that would allow a doctor to switch employers. It sounds like they may have a J1 issue, and changes in employment can occur without affecting their waiver, but it's a very precise area of the rules that you would want someone to help them that has experience doing that.
Yeah, especially in an area.
Okay, very good. Well, I will call into the company then.
Okay, thank you, Marina.
Thank you very much.
Hi. I never saw anything related to TN visas. Do you have any information on that?
Well, that's really interesting because, during the election campaign, NAFTA was going to be eliminated on the first day that President Trump took office. And we haven't heard much about NAFTA since then.
I've heard reports of there's sort of parents supposedly just having internal discussions about modifying the treaty. Now, whether or not that's going to impact immigration remains to be seen. Okay, if it does, then you just have to understand sort of the mechanics of the TN and how it came into being. Right, it was all through NAFTA. TN stands for Trade NAFTA. And so the visa benefits there could be modified if the three parties to the agreement so desire, right? Canada, U.S., and Mexico.
Okay, thank
but
you.
As of now, no firm word on any kind of changes.
Okay, thank you.
If there's someone that is really very important to your operations and you're concerned about the longevity of their ability to work for your company, then certainly you may want to look at other categories that might be available to the individual to protect them and to protect the company.
Thank you.
You're welcome. Hello?
Hi, I have a question regarding the ramifications of the EO for the asylum applicants who are waiting for or recommended for approval but are awaiting their background checks, and how would this pan out?
So let me make sure I understood your question. Your question is about those individuals who have been recommended for approval for asylum, but they're awaiting their background check?
Correct.
Okay, and are these individuals from one of the 7 countries?
Correct.
So at this time, since the injunction, and based upon guidance from USCIS, then they're still going to be at a waiting. I mean, these background checks can take. We've had them take more than a year for individuals from these countries, even before this, even during the Obama administration. So it's really at this point, based upon what the law is and the status of this order, it's ultimately, as long as the background check comes in without any questions, then their applications should be granted. But we've certainly seen very lengthy delays in the completion of the background checks for individuals from these countries for several years now.
If the executive order, if the EO is reinstated, then we're going to have to wait and see how the adjudication of visa benefits here in the U.S., how that's going to be affected, right? We were just starting to get guidance, more and more sort of interpretation and specific guidance from the government when the injunction was issued.
And I have a second question, if I may. In the EO, in the first one, there was the word INA benefits in addition to visas and non-immigrant visas and immigrant visas and INA benefits. Does that mean, for instance, if somebody is a green card holder and he or she files for citizenship from one of the 7 countries, that application would probably be blocked because it would be considered an INA benefit?
Based upon the guidance that was coming out from USCIS before the federal judge issued the TRO, naturalizations were proceeding. And there is a memo from USCIS indicating that even petitions and applications that did not confer a travel benefit for individuals from these 7 countries could continue. And that was even before the TRO was in place. So what the EO said and how it's being interpreted and implemented is quite different in certain areas.
That's right.
All right, thank you.
You're welcome.
Everybody, thanks for having this thing today. Here's my question for you. It sounds like everybody feels that the H-1B dependent IT consulting firms are going to come under some really heavy scrutiny beginning very soon. My question is, if you are an employer that uses some of these consultants on site, but you also have H-1B employees in completely unrelated roles, are you exposed, is there any more risk that you are exposed to by having these consultants on site other than the risk of losing a consultant that you've come to depend on?
That's a great question. I think directly no, but indirectly maybe. And by that I mean, and this is something that I've sort of discussed with clients over many times over the years, and that is whether or not your consultants are really consultants. Whenever you bring on someone like this, you always have to make sure, and this cuts across employment law, tax, as well as immigration, you want to make sure that these folks are truly independent contractors, that they satisfied that test to the extent possible. And so the more of these kinds of workers you have on board, the greater the risk, I think, that they would be found to be your employees, and then you would be liable as the true employer, right? And that would be I-9 liability because you haven't I-9'd them, you haven't sponsored them. And so indirectly, I think, to answer your question, you could see some impact if these IT consulting companies are being targeted.
Thank you.
Mm-hmm. So, John, if
too late.
Hello. Hello, can you hear me?
Yeah.
Hello.
Hey, how's it going? This is Junaid here. Thanks very much for doing this. Pretty fascinating. I just had one question. I guess you sort of answered it before. My question is really regarding the bill that was proposed by the Democrats, I guess, or by one Democrat. Will the proposal to remove the level 1 prevailing wage, will that apply to current visa holders?
Well, the way the legislation was written, it would be applied to cases filed prospectively. It couldn't be applied to petitions that have already been approved.
Right.
Historically, once you've secured the labor condition application for an H-1B, they've pretty much left that alone, they being the government, right?
Now, extensions
would be, fair game.
Exactly.
Yeah. Or amendments.
So I see. So once, like, say the 6 years is up and then you extend for, like, year on year, then it applies?
It could, yeah.
If this legislation was passed at its current form. There's a lot of ifs there.
Sure. Understood. All right. Thank you.
Mm-hmm.
Hi, my name is Ram, and thanks for having this platform. And my question is, if people are having a valid visa, can they travel who are not part of those 7 countries, though?
Okay, Ram, I just want to repeat that because I want to make sure that we understood it. Your question was, if an individual has a valid visa, can they travel if they're from one of those 7 countries, or
not?
If they're not from one of those 7 countries?
Yeah.
So this is anyone this is any person who's not from Iran, Iraq, Syria, Libya, Somalia, Sudan, or suddenly I'm missing my. But one of those 7 countries.
Right. So the answer is the executive order. We've gotten a lot. We fielded many questions from folks who are nervous because and rightfully so, right? They see something like this issued by the government and they want to know if it's okay for them to travel, even if they're not from one of those 7 countries. And the answer is yes. I'll have a sort of an additional point to make in a second, but you always want to make sure that you have everything in order, right? That's a very general answer. You want to make sure that you have everything in order in place for you to be able to leave and come back without any issues, okay? Even without the order being in place, would you potentially face more questions at Customs and Border Protection? Maybe. They're definitely on high alert, if you want to call it that, and so you might feel a different sort of attitude by officers when you come back to the U.S. this time around, okay? So now I've also fielded a lot of questions from folks who were from countries that were they're rumored to be targeted or next on the list, right? Some of them included Lebanon, Egypt, Pakistan, And another country that I've never heard of, Jim.
Some didn't exist.
Southern Philippines? I've never heard of that.
Yes.
So that was a rumor, and I think a lot of immigration lawyers found where the rumor was coming from, and it was actually, I think, a company that was trying to drum up business, which is really horrible. And so, if you're from one of those other countries or you feel like you could be next on the list, then, you're taking a little bit of a risk. We don't know what's going to happen. It's a calculated risk. But otherwise, if you're not from one of those 7 countries, there's no travel ban, right? You're fine.
So does that apply to the H-4 visa holders as well?
Exactly. Same for the H-4s.
Okay. Yeah. Thank you.
Sure.
Hello. I have a question for individuals who are not part of those 7 countries. The question is this AR-11 which you're talking about. Is this applicable for all visa categories and green card? And what address we need to update? Is it the apartment address or the office address?
It is the home address. So the AR-11 is available online on the USCIS website, and if you simply Google AR-11, you will find it, as well as instructions as to where to send it. And you can actually send it electronically.
It's probably the easiest immigration form you're ever going to complete in your life. It's very simple.
So how do I know that what address they have in their record as my current address?
Well, your home address has been listed depending on how you got here and what immigration benefits were filed on your behalf, but your home address would have been listed in one of those filings.
Mm-hmm. So let's say you had an H-1B petition approved, you went to the consulate and you identified an address, or you moved after you arrived here. Any move requires the submission of an AR-11. So you just want to, every time you move, make sure that you're filing the AR-11 and keeping a copy for your records in case they don't receive it. Because our theory is that there are thousands and thousands of boxes with thousands and thousands of AR-11s sitting in some storage room, probably in Lee Summit, Missouri. And so you need to make sure that you're documenting all your notifications, because it may be difficult to rely upon the government to be able to find those AR-11s.
Okay, so to be frankly speaking, I don't know what they have in their record right now as my current address. But for sure, I know that I moved I changed my residential address in last year.
Well, the thing is, you're not alone, right? And it may be helpful to schedule a consultation to discuss the best strategy. But you got to understand, you're not the only one that maybe missed that. But because of the reprioritization of deportation, those individuals who are subject to deportation, you want to be extra cautious now and make sure that everything is documented and that you do notify immigration when you move.
Okay, so I will work with my HR specialist and see, because my visa is sponsored and, my company processed all those documents related to petition. So I will work with them to find out, what address we have with USCIS and what we need to do in address in order to update my existing address. So I will work with them. Thanks.
Okay, very good.
Okay, one question. Sorry. If I'm not mistaken, I believe changing the home address doesn't trigger reissuance of the green card, right?
No, that's not. It doesn't you don't have to get a new green card just because you moved. You just are required to notify immigration that you moved up until the time that you have your citizenship.
Got it. Got it. Okay. Thank you.
With all the focus on worksite enforcement, especially around L's and H's, and then the mention of the B1 kind of in that grouping, do you anticipate or foresee that they'll start looking for B1s who are on site as well?
That's a very, very good question. I would anticipate more questions at the port of entry because that's where many of the Bs are sort of reviewed, right, the purpose of their visit and so forth. And I would fully expect questions along the lines, well, how many B1s have you got? Are you hosting right now, and why are they here? And they might be after the folks who are there working without authorization.
And so, if they see a pattern, or there might be an increase in the number of I-9 audits, and whenever the trend now with I-9 audits is not simply to ask for the I-9s, but also to ask for payroll and documentation regarding,
the W-2s.
W-2s,
they want
1099s.
They want to know who your contractors are, 1099s, a list of Bs that you're hosting. So all these questions are are typically now asked by ICE in an audit situation. Okay. Well, very good. I think we're going to conclude the presentation. I think we've gone over our time by a little bit. We want to thank everybody for joining us, and as we mentioned before, we will have more of these as news develops, and we'll definitely issue alerts and new articles as well.
Thank you very much, and just if you have questions, please feel free to follow up with us offline.
Thanks, everybody.
Bye-bye.